Imagine you're a judge. A case lands on your desk, but the law isn't crystal clear. There's no obvious statute that applies to this case. What do? Do you make new law? Do you just go with your gut? Or do you dig deeper into the principles that are already in play in your country? Hi and welcome back to the channel. In this channel, we try to answer questions related to the law, including asking the more philosophical questions like what is law and why do we follow law? Today we are diving into one such philosophical discussion which was presented by Ronald Dworkin in his Theory of Law. He argues that judges don't have free rein, but instead should decide cases through integrity, interpretation, and the search for the one right answer. And by the way, I recently published a book, The ABCs of Jurisprudence, which tries to answer this question of what is law. And in one of these chapters, I discuss Ronald Dworkin's interpretive theory. And if you're interested in picking up a copy of it, it's available as an ebook on Amazon Kindle and as a paperback on Amazon. I'll leave a link to it in the description below. Anyway, let's discuss Ronald Dworkin and the theory of interpretation. Traditionally, some legal thinkers like H.L.A. Hart argue that when judges run out of rules to decide cases, they can make up new rules, meaning they can use their discretion to create new law to decide cases, like legislators in disguise. Ronald Dworkin thought this was dangerous. He believed that judges shouldn't be politicians in robes. He believed that a judge's job was not to create new law, but to interpret the existing principles in order to find the one right answers which are consistent with the legal system. Imagine a soccer referee. Hart would say that if the rule book doesn't cover a situation, like a drone dropping a ball into the pitch, the referee would have discretion to invent a new rule. Dworkin, though, would argue that the referee should interpret the spirit of the game, fairness, equal opportunity, and make a decision in a way that fits those existing principles. Now let's break down Dworkin's thinking. Dworkin's theory of integrity suggests that judges should treat the law like a chain novel written by different authors over time. Each judge, when deciding a case, is like a new writer adding a chapter to the novel. Their job is to write each chapter in a way that the story works together as a whole in a coherent way. Think of the Marvel Cinematic Universe. Each director adds a new movie. They can't just ignore what came before, otherwise the fans would revolt. Instead, they need to make their film fit with the overall storyline, themes, and tone. Judges do the same when they write new judgments. For example, imagine a judge facing a case about freedom of speech on social media. But under integrity, the judge looks at the bigger legal story, past free speech cases, constitutional principles, and the values like fairness. So the decision that they reach must fit with the larger story so that the law doesn't feel random and contradictory. In other words, the law must seem like a set of principles that work together and not a patchwork of isolated rules. So how does a judge actually do this? Dworkin gives us the interpretive theory of law. And according to him, this interpretive theory has three stages. Number one, the pre-interpretive stage, where you identify what rules and practices exist. For instance, statutes, constitutional provisions, and past judgments. Number two, the interpretive stage. This requires the judge to ask, what is the best moral justification of these rules? Why do they exist? What principle do they serve? And find the best interpretation. Number three, the post-interpretive stage. Make sure that the interpretation that the judge has chosen is the best fit and justifies the legal system as a whole. Think about driverless cars. If one crashes and the statute doesn't mention autonomous vehicles, what do judges do? Number one, the pre-interpretive stage. Look at the existing traffic laws, negligence rules, and product liability rules. Number two, the interpretive stage. Ask what principles those rules serve. Safety, accountability, fairness, and find the best interpretation of the law that suits these principles. And number three, the post-interpretive stage. Make sure that this decision suits AI-driven cars without contradicting the overall story of tort law. For example, if a judge is deciding a case on whether AI-generated art is protected by copyright, then the judge is not going to simply look at the statute because the statute probably doesn't deal with it. Instead, the judge would ask what kind of principles underline the copyright law. Creativity, rewarding human effort, encouraging innovation, and how can these principles be furthered in a way that best fits and justifies the existing copyright law? Meaning, the new interpretation of the law must be consistent with the existing copyright laws. Take for example the famous monkey selfie case where a monkey snapped a selfie of himself. They had to decide if copyright law could apply. They didn't just look at the statute word for word, but they looked at what principles copyright law was trying to further and ruled accordingly. They held that the monkey cannot own the copyright and that the copyright was held by the photographer who set up the camera. That's Dworkin's interpretive process in action. Here's where Dworkin got bold. He argued that every legal case has one right answer, even the hard cases. Why? Because if judges properly interpret the law through integrity, balancing the principles that best justify it, then one decision will emerge as the most coherent, morally defensible outcome. And this will be the same outcome regardless of who makes it. To illustrate this, Dworkin introduces us to his ideal judge, Judge Hercules. Hercules has unlimited time and skill and accepts integrity perfectly and then carries out the interpretive process to find the one right answer. According to Dworkin, every real judge should aspire to Judge Hercules. Think of it like a puzzle. Many pieces may look like they almost fit, but only one arrangement completes the picture without contradictions. Or like solving a crossword puzzle. Many words might almost fit, but only one set completes the grid correctly. That's Dworkin's one right answer. Now critics push back here. They argue that the law is messy and values conflict, and therefore sometimes there isn't one right answer. For example, take abortion rights cases. Some argue in favor of the principles of personal autonomy, while others argue in favor of the principles of protection of life. Critics argue that pretending that there is only one right answer oversimplifies this complexity. Now, Dworkin's theory has been hugely influential, but it isn't without criticisms. Number one, it's considered to be too idealistic. Real judges face practical limits like unclear precedents, political pressure, and personal bias. Expecting them to always find the perfect principled answer may be unrealistic. For example, lower court judges dealing with huge case backlogs often don't have the time to construct grand interpretations. Number two, the disagreement problem. People genuinely disagree on what the best moral interpretation is. So even if a judge thinks they've found the right answer, another judge might interpret the principles differently. Think about free speech versus hate speech cases. Judges disagree on where to draw the line even when looking at the same principles. Number three, the democratic concern. Some argue Dworkin gives judges too much power. If they are not applying law but interpreting it through morality, they're acting like unelected legislators rather than neutral arbitrators. Ironically, this is exactly what Dworkin tried to avoid and critiqued about positivist legal theory when he said that judges shouldn't use their discretion. For example, when courts legalize same-sex marriage because they believe it matches the integrity of the legal system, although it isn't expressly allowed by the law of the land, critics could ask whether that's interpretation or judicial lawmaking. So how should judges decide cases? For Dworkin, it's not about creating laws out of thin air. Judges should accept the integrity of the legal system, then consider the principles that underline that legal system and interpret those in a way that creates coherency of the legal system. And whether you buy into this argument of the one right answer or not, Dworkin challenges us not to see the law as a simple set of rules, but to see it as a set of principles which are part of a coherent legal system. What do you think? Should judges try to find the one right answer, or is the law too messy for that? Let me know in the comments below. And of course, I discussed Dworkin in more detail in my book ABCs of Jurisprudence, which you can pick up from Amazon. I'll leave a link for it in the description below. And please do consider liking the video and subscribing to the channel if you enjoy content like this. I'll catch you in the next one. Take care. Bye.